Hi, this is Professor Unmac, and I want to do this narrated PowerPoint in part to sort of pull together all of the various things I've been asking you to read about the Fourth Amendment and kind of put them all in one place. Sorry, had to pause there for a minute because one of my dogs was barking. Anyway, so this last week and now this week, we're going to be talking about the Fourth Amendment. So I know that some of this material that I'm going to be covering, you've already had been exposed to. So there's a little bit, or a lot, I guess, of overlap. But hopefully between all the stuff I've asked you to read and all of the, and this video, you'll have a really good idea about what the Fourth Amendment is all about. So I want to start, before I do anything else, I want to point out I am not a lawyer, so I can't give legal advice. I say this every semester, every time I teach constitutional rights. When we talk about the Fourth Amendment in class, people always have lots of questions. Well, what about if the police do this? Well, what about if the police do that? Well, I can give you a broad overview of some of the really important decisions the Supreme Court has made about what the Fourth Amendment means. But the court's work will never be done in this area because there's new technologies that come up, there are new situations that come up. Obviously, the membership of the court changes. And so there's sort of an ongoing interpretation of the Fourth Amendment. It's also one of those areas that gets adjudicated a lot. There are a lot of cases that have come before the Supreme Court. I don't expect you to know everything there is to know about the Fourth Amendment and every little, what about this, what about that, little picky little thing about the Fourth Amendment. If you go to law school, you can learn all the extra stuff about the Fourth Amendment. So I do want to give you a little bit of an overview here. So here we go. So this is what the Fourth Amendment says. It's got a lot of stuff packed into it. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. There's a lot of stuff in the Fourth Amendment. So if you look at some of the words, you'll see your right or our right as people in the United States to be secure in our houses, to be secure in our knowledge that the government's not going to search our stuff in a way that's unreasonable. So right there, the Fourth Amendment acknowledges implicitly that there are going to be times when it is reasonable for the government to search your person or your house or your papers or your effects. So the first thing that we want to think about in terms of a search is whether the search was reasonable. If the search was unreasonable, then it's not supposed to happen. And then the other thing that we want to talk about with regard to the Fourth Amendment for purposes of this class is this phrase, and no warrants shall issue but upon probable cause. So one of the things that you'll learn, or that you've probably no doubt already learned if you did some of the work that I assigned for you last night, not every search requires a warrant. But when the police are going to do a search in a way that would generally require a warrant, they're going to search your house, for example, almost always would require a warrant. They have to show somebody other than a police officer that they have probable cause, that it's likely they're going to find what they're looking for. So that generally means that they've got some evidence already that justifies the search. Supported by oath or affirmation means generally that they take it to a judge or somebody from not from the police department, because obviously they would give themselves warrants all the time. So you want somebody else to look at it. And particularly describing the place to be searched and the person or things to be seized. So when the police secure a warrant to do a search, that warrant is going to specify where they're allowed to search and what it is they're looking for and what they can take. So there are a lot of cases that have come before the court that are based on the idea that the police didn't follow what the warrant said, or they went beyond the scope of the warrant, or they conducted a search without a warrant. and the court has had to really grapple with whether or not something was a search and whether or not that search was reasonable, etc. So there are three things that I want to kind of focus on for the purposes of this narrated PowerPoint. Three kind of questions. Oops, those were supposed to fly in one by one, but they did not. So first is, what's a search? And we'll talk about some cases where the court has had to decide if what the police did was actually a search. If it wasn't a search, then the police maybe didn't do anything wrong. Do all searches require a warrant? Is every warrantless search an unreasonable search? And so we're going to talk about the conditions under which the court has said a search might not require a warrant, the types of searches that don't require a warrant. And then the last thing I want to talk about is how the Fourth Amendment is to be enforced. What happens if the police conduct an illegal search? What's the remedy? How do you punish the police? How do you ensure that somebody's rights are respected? Right? So we'll talk about that. So there are lots and lots of interesting questions that have come before the court, cases that have come before the court having to do with whether or not something is a search. And so most of this you're going to also read about, so I don't want to go too quickly, but I do want to kind of put these cases that you'll read about in different places and put them all together sort of in one place. So two cases that kind of got us started in the modern time in terms of whether something is a search or not are these really important and very famous cases. The first was decided in 1988 called Olmstead versus the United States, and the second was decided in 1967 called Katz versus the United States. And they both involved a question of whether or not it was a search within the meaning of the Fourth Amendment for a phone line to be tapped, right? The government's not actually going into somebody's house. They're just eavesdropping on their conversation with a technology that wasn't around in 1787. So in 1928, in this case, Olmstead versus the United States, the police got the permission of the phone company, which owned the phone lines coming out of Olmstead's house, and they tapped the phone line and listened in on Olmstead's conversation and then used the evidence the conversations that they seized against him in court. And in 1928, the Supreme Court said, yeah, that wasn't a search. He didn't have an expectation of that somebody wouldn't listen in on his phone conversations. As long as the police didn't go into his house, they didn't have to ask his permission. They didn't have to have a warrant because they didn't go into his house. Well, after some time, some change on the court, some different ways of thinking, a case came before the court involving a guy named Katz, and he was arrested. The police tapped the phone booth. This is a TARDIS, but this is a phone booth. The police tapped a phone booth that Katz was using to conduct his illegal activity. I believe that he was a bookie. So he used a phone booth to have people place bets and that kind of stuff. So they tapped the telephone line. And when it came before the Supreme Court, the court could have just ruled the same way they ruled in Olmstead and said, look, Katz doesn't own the phone booth. The phone booth is a public place, and so the police can tap that phone and listen to the conversations of this guy Katz without violating his Fourth Amendment rights. But the court did not do that. Instead, the court sided with Katz. And what they did in this case is they said the Fourth Amendment protects persons, not necessarily places. So what the court said in Katz is that the government is conducting a search when they are listening in on somebody's phone conversation when that person has established an expectation of privacy. If Katz had been sitting at a Starbucks, which didn't exist in 1967, but let's say he was at a donut shop or something, and he was talking on a phone that was out in the open or talking to a person sitting at a table, there's no expectation that nobody's going to overhear your conversation. But the court said in Katz, if you're in your home or if you're in a phone booth and you've closed the door to that phone booth, you have an expectation that nobody's going to be listening to that phone conversation. And so the court said that was a search. They seized his conversation without a warrant, and it actually was a search. And so now, if the police want to tap somebody's phone line, they generally would have to get a warrant to do that. If somebody is talking on their cell phone, plotting a crime in full view of everybody and, you know, out in the open or something, that's a different thing. But that's why cats is a really important question. Another thing that's come up, and it was in the reading, and it's in the reading for this week as well, is a question of how far does your expectation of privacy go? And where can the government or can a police officer look for evidence of crime without it necessarily being a search that would require a warrant? And this case in 1984, called Oliver versus the United States, involved the police searching not the home or the driveway or the front porch. That area is generally what's known as the curtilage of a house. It's the house and the area immediately surrounding the house is considered what's called the curtilage, and generally the police can't search within the curtilage of a property without a warrant. Houses are, generally speaking, the police would need to have a warrant to search a house. In Oliver versus the United States, the question was, how far does your expectation of privacy in your home go? And in Oliver versus the United States, the court dealt with this issue that's come to be called the open fields doctrine. This is not Oliver's house. I just found this picture on the internet. But what Oliver was doing was growing marijuana, and he had a big piece of property, and the police went on his property. I think he even had no trespassing signs up, and they either flew planes over his property or they went onto the property and they found these pot plants growing, so they seized them. And the court ruled that that actually wasn't an illegal search, because they said that people don't really have that broad of an expectation of privacy. If you own a big piece of property, you don't have an expectation that nobody's going to be able to see over your fence or fly a plane over your fence and see something that is going on outside the curtilage of your house. And so that's not really a search in that sense. So even if somebody puts no trespassing signs on the edge of their property, I think in Oliver, the property actually extended about a mile. The court said, you just don't have that broad of an expectation. This doctrine has been extended somewhat. So for example, things that people throw away are not, there's no expectation that somebody won't go through a pile of trash or something and find potentially incriminating evidence. So this open fields doctrine is also really important when we're talking about whether something is a search. Again, if the police come onto your front porch and conduct a search within the curtilage of your house, chances are they would not be able to legally do that without a warrant. In Kylo versus the United States, there are lots of cases that we could look at that involve sort of the use of new technologies. Kylo versus the United States involved at the time a relatively new technology, and that is heat-seeking devices. So I don't know that much about cultivating marijuana, but I know that you use a lot of heat to grow a pot inside a home. And so they suspected that Kylo was growing marijuana in his home, which he was, or he wouldn't have been arrested. And they took an infrared gun and they stood outside his home without a warrant, and then they searched inside his house for heat. And the police struck his conviction down. They said that technology allowed the police to do something that would require a warrant. They said that actually was a search. They searched within, they didn't go into his house, but they as good as went into his house because the infrared allowed them to search using something other than their eyes or their ears or something like that. That this was an extraordinary technology that they used to sort of breach his expectation of privacy in his home. So that it was considered to be a search that would require a warrant. U.S. versus Jones and Carpenter versus the United States also involve the use of new technology and how the Fourth Amendment is going to apply to new technologies that could potentially give the police tools for law enforcement, but also potentially unconstitutionally violate somebody's right to be protected against searches without warrants. So U.S. versus Jones involved a GPS device that the police put on Jones's car, and they did not tell him that the GPS had been, and they didn't get a warrant to do it. They put the GPS monitoring device on his car, and then from a distance, from a computer, they followed his movements and used that evidence to get him convicted under federal drug charges. The United States government justified this by saying it's just like the police following a car. Police officers can follow a suspected drug dealer and write down what that suspected drug dealer is doing, where that person is going, who they're interacting with. They can take pictures, etc. And the police argued that this was just a different tool for doing that. This just allowed the police to monitor the person without having to follow them. But the Supreme Court disagreed in 2012. They struck Jones's conviction down and argued that it wasn't the same thing. They said that without getting a warrant, police officers, they said it's one thing for a police officer to follow somebody around. One police officer or one team of police officers would be following one person at any given time. But if you allow the use of GPS monitoring without a warrant, police officers could follow hundreds of people. They could just sit at a computer bank and have all kinds of screens going on, and they could follow all kinds of people without having to have any probable cause, without having to have any reasonable suspicion. They could just go on sort of a fishing expedition. And the court said that if you want to do that, then you have to have a warrant to be able to do that under most circumstances. Carpenter versus the United States involved a different kind of case. This case involved whether or not it was a search requiring of a warrant for the police to access through a phone company the GPS location information from somebody's cell phone. The idea being the police made the argument that this information is actually public because it's collected automatically by the phone company or the server, the cell phone server, and you don't have an expectation that nobody will know where you were going. And they actually followed Carpenter. They got the data from the phone company going back months against Carpenter. And the US Supreme Court said that they actually should have had a warrant to do that. That actually was a search. Even though they weren't searching his cell phone itself, they were searching Carpenter's whereabouts. And the net that they cast was so wide that they knew everything that Carpenter had done. They knew if he went to the doctor, they knew whose houses that he went to, and a lot of that information had nothing to do with criminal activity. And so the court has ruled in a lot of really interesting cases, like what's a search and what's not a search. But generally what they've said is people have a reasonable expectation of privacy. They have a reasonable expectation that they can go about their daily lives without needing to worry about the prying eyes of the police, and that they're going to be protected in that right. And if the police think that somebody's done something wrong and they want to do a search, well, in these kinds of situations, you gather your evidence, you take it to a judge, you say, this is what we need to search, this is what we think we're going to find, this is how long we want to do this search for, etc. And then people have a right to challenge the warrant. They have a right to have a lawyer look at it, right? It's part of what we call due process of law, that the government's processes need to be fair. So lots of interesting questions about what constitutes a search under the Fourth Amendment. I think this information is super, super interesting. The second thing that I want to talk about is this notion of warrantless searches. Under what conditions can the government sometimes conduct a search without having to get a warrant first? So not every warrantless search is an unreasonable search that would be struck down by the court. So I'll just go through a few of these. Some of these I asked you to read about for this week as well, so there's a little overlap, but I want you to sort of zero in on certain cases because I don't want you to feel like you have to learn every single case that's mentioned in the readings. I'm trying to narrow down the scope of how many cases I'm going to ask you to learn for this section of the course. So one of the areas where the police can do searches without a warrant is what we call searches incident to a valid arrest. So if the police are arresting someone, they have a right to search the person, him or herself, to make sure they don't have a weapon or something that could hurt the police officer. And if they find evidence of crime, then sometimes that evidence can be used against that person. If they are serving a search warrant or an arrest warrant, if they go to somebody's house with an arrest warrant, they can also generally search the immediate area that the person is in to make sure, again, that they don't have a gun or a weapon in easy reach. And if they find something that is related to the crime that they're arresting the person for, like they find drugs or they find illegal weapons or something like that, then they can seize that evidence, generally speaking, without having to go back and get a search warrant if they have a valid arrest warrant. There are some exceptions to that, and these are the exceptions that I want to give you that sort of prove the rule. So Shamel versus California, the police, when they arrested Shamel, they actually did a comprehensive search of his whole house, and the court said that they went beyond what was necessary to make sure that there wasn't a danger to the police or things that they could see with their eyes as they were arresting this person. So if they have an arrest warrant, for example, that doesn't necessarily give them the right to go through go through all the bedrooms and look in the drawers or open up the cupboards in the kitchen or something like that. Riley versus California is another one of these exceptions. Riley was arrested on suspicion of having participated in a gangland drive-by shooting. And when the police arrested him, they opened and searched his cell phone, and they found pictures and text messages that they then seized and used as evidence in Riley's trial. Riley's lawyers argued that that was an illegal search because the police should have had a warrant. The cell phone was not a weapon. The cell phone itself was not evidence of crime. And so they argued that the police should have had a warrant to search Riley's cell phone so that Riley could have a lawyer look at it, etc. The police argued that this was no different than looking through Riley's wallet, which they actually would be able to do without a warrant when they arrested him. Riley's lawyers argued that it was actually more like going through Riley's computer because cell phones contain so much data and so much personal data about our lives that you could never fit into a wallet or you could never stick in your pocket or something like that. And the Supreme Court sided with Riley, and they established this sort of constitutional provision that the police, if they want to look at what is on somebody's cell phone and that person does not give them consent to do so, then they would need to get a warrant first. So those are some exceptions that prove the general rule that searches can be conducted incident to a arrest. The second area that we could look at is this notion of hot pursuit and what has come to be called the Terry stop. This is actually kind of controversial in some areas, and in some areas it's not. So let's say the police are in hot pursuit of a suspect and they tackle that suspect. They can then search that suspect, especially if they're looking for weapons or drugs or something like that, without getting a warrant first, right? They're doing their job and the person ran away. Terry stops are a little bit different. They come from a case called Terry versus Ohio, where the police in the city in Ohio they were on their beat. They were walking around their neighborhoods that they patrolled, and they noticed this guy Terry and some of his friends standing outside of a business that wasn't open. And it was the kind of business that was susceptible to robbery. And they're police officers. They're trained to look for evidence of criminal behavior. And these guys looked suspicious to them. They thought, why would they be standing there? This business isn't open. This isn't generally a place where people would gather. It's not near any apartments or anything like that. And so they went up to them and they asked if they could stopped them and asked them some questions. And in doing so, they patted Terry down. They wanted to make sure that he, while they were talking to him, while they were asking questions, that he didn't have a weapon that he could use to hurt the police. And in fact, he did. And they seized that and they arrested him. And his conviction, the court said, the police did not violate his Fourth Amendment right, that when the police are doing their job, they can search somebody on a standard called reasonable suspicion, right? Getting a warrant generally requires probable cause. That's a higher standard than reasonable suspicion. The court said, as long as the police, based on their training, have reasonable suspicion that a person might be planning to commit a crime, they are within their rights as police officers to do what's sometimes called stop and frisk. It's generally referred to legally as a Terry stop, to make sure that the person that they are talking to does not have a gun or a weapon. And then if they find evidence of crime, they can seize it and use it at trial without a warrant. I said it's controversial because there are some people who argue, a lot of civil rights organizations and a lot of civil rights leaders argue that the Terry stop is often misused, that it can be used in a way that may amount to racial profiling, that the police might be unreasonably suspicious of especially young men of color, and then assert reasonable suspicion to do stop and frisk when really they don't have any reasonable suspicion other than the fact that the person is maybe a black man in a wealthy neighborhood or something like that. So it's controversial, but the court has ruled in a number of cases that when the police are doing their job, if they have reasonable suspicion, and obviously that could be argued in court whether they did or not, that is enough. They don't have to have probable cause. They don't have to have any actual tangible evidence. They have to have what's called reasonable suspicion. Another area is, and it might be obvious, but we'll talk about it anyway, is if the police come across evidence of crime in plain sight, right? They're doing their job. If they see somebody commit a crime, they don't have to rush off and get a warrant before they can search that person and seize evidence of crime in plain sight. So here's an example. This is a picture of a person texting while driving. Well, in I think every state now, it's illegal to text while you're driving. So if a police officer drives by somebody, looks in the window of their car and sees them talking on their cell phone or texting or reading a magazine or watching a movie or something like that, that's distracted driving and it's illegal. And it's specifically illegal under California law, for example, to text while you're driving, and they don't have to go and get a warrant. By the time they're done getting a warrant, you're going to be gone, right? Not you, because you would never text and drive. I just thought this was a funny cartoon. Of course I ate the fish. He was in plain view. But I'll give you an example of a case that's an exception to this. So something actually has to be in plain sight, right? If the police have to look for it, it's not really in plain sight. And that's what happened in this case called Arizona versus Hicks. The Supreme, in this case, the police got called to an apartment somebody had shot a gun through the ceiling of this guy Hicks's apartment. And so Hicks called the police because somebody shot into his apartment. And when the police got there, they're talking to this guy and looking at the hole in the floor or doing their job or whatever. And they noticed this stereo, I think it was stereo equipment. And they had a list of stolen items that they had been looking for. And there was something about the stereo equipment that piqued their interest. And so they pulled the stereo equipment away from the wall to look at the serial number, the identifying number that was on the stolen stereo. And lo and behold, it was the stolen stereo. But the Supreme Court said that actually was not a plain sight. It wasn't inevitable that they would have found that stolen property. They actually had to manipulate it and move it to be able to find it. So cases come before the court having to do with plain sight and inevitable discovery. And this is an exception. This is an example of where the court might say, hey, you know what? Doesn't seem to me that that evidence was in plain sight. So all of these things get played out in court, right? The government argues that the police did not violate the Fourth Amendment, and the defendants argue that the police did violate the Fourth Amendment, and then the court makes a decision that applies in cases going on from there. So that's plain sight. So the next area that comes up a lot when we talk about warrantless searches is cars. The police don't always have the right to search a car without a warrant, but in a lot of areas, this is a lot of cases, this is an area where the police can search without a warrant. And I mean, the most obvious thing is if somebody's speeding, let's say somebody's speeding, or they go through a red light, or they have broken some sort of traffic rule, the police don't have to get a warrant before they pull somebody over, even though they have temporarily seized that person and kept them from going on their merry way. So generally speaking, the police don't have to have a warrant to do their job when they are when it involves cars. And once they pull somebody over, they can, without having a warrant, ask that person to get out of the car, and they can do a Terry stop and pat them down to make sure they don't have a weapon. And they can look into the open areas of the car without a warrant. So for example, if somebody is pulled over for speeding and they have a packet of heroin on their front seat, or a gun, or an open container of alcohol or something like that, the police don't have to get a warrant before they can seize that as evidence. So if the person has an illegal weapon, let's say the person has, I don't know, a nuclear weapon or something like that would be illegal. And part of that is because the police have a right to do their job without fear that they're going to be injured. So they have a right to make sure that there's not a weapon handy, there's not a knife lying around, or a gun, or something that could be used to hurt the police officer. And so what they can see with their own eyes is within plain sight, even though it's inside of a car. So that does not mean that if the police pull somebody over, they can automatically pop the person's trunk and go through the trunk to see if there's any evidence of crime in the trunk. Generally speaking, there are exceptions to everything, but generally speaking. But they can search the open areas of the car. Now, if the police say, hey, would you pop the trunk so we can look at what's in the trunk of the car, and the person pops the trunk, well, then they've given consent for a search, but that's not necessarily needed. This case, I bring this case up to you because it's a super interesting case, but it's one of those examples of where the court has told the police when they've gone too far with a warrantless search. So Knowles, in the state of Iowa, was pulled over, and he was given a citation, but he was not arrested. Nonetheless, the police did a comprehensive search of his car and found evidence of illegal activity, because if not, he wouldn't have been arrested. And then they arrested him, and then they used the evidence that they seized in trial against Knowles. And Knowles' lawyers argued that the police didn't have any reason to search his car comprehensively. They weren't worried that he was a danger to them because they didn't arrest him. They gave him a ticket, but clearly they were not searching the car because they thought that they were in jeopardy. The police were in jeopardy, and they didn't have any probable cause to search his car. And so the case came to the court, and when the court made their ruling in 1988, they sided with Knowles. And they said, if a police officer is going to argue that they were justified in conducting a comprehensive search of somebody's car because they were worried that the person was a danger to the public or to the police, evidence of that would be that the person got arrested. But if you can pause the PowerPoint and look at this little cartoon if you want, but this cartoon is related to a case called Georgia versus Randolph that involves this fifth area where the court can do warrantless searches, and that has to do with consent. Basically speaking, the court has said that if somebody gives consent for a search, the government does not have to get a warrant before they conduct the search because they were given consent. So if the police knock on somebody's door and they say, hey, can we come in and search your house? And you say, sure, come on in and search my house. Then in most cases, you can't really complain that it was an illegal search when consent was given. Sometimes consent is required before somebody gets put on probation, for example, or it might be a condition of parole that a person who'd been convicted of a crime, agree to be searched by the parole officers or by police officers doing parole checks and that kind of thing. But a lot of times, issues that come before the court involve not necessarily somebody who's on parole or something like that. So, for example, if 5 people live in a house and there's only one person home, that person can give the police permission to search the house. They don't have to get permission from everybody who lives there. The police just have to, they just have to be reasonably certain that they've been given consent. The court even said they don't have to have a warrant. They could get consent from somebody who, even if it turns out that that person doesn't live there. So there was a case involving the police. They walked up to this young woman who was sitting on the steps of a house and said, hey, I don't know, somehow they got to talking to her and were indicated that they really would like to get inside and search the house. And she's like, well, I've got a key. So they said, well, will you let us in? And she said, sure. And she let them in and they did a search, and it turns out she didn't live there. She had a key, but she didn't live there anymore. She'd been kicked out or she had left and moved somewhere else, but she still had a key. And the court said, the police don't have to verify that the person who gave consent was authorized to get consent. They got to be allowed to do their job. So even in this case, the person didn't live there. The court said that was good enough. Here's my exception to the general rule of consent. This case involved Georgia versus Randolph. The police got called to the Randolph house because it was a domestic dispute. And while they put him in the police car, and while they were questioning her, she was pissed, right? Oh, sorry, she was very mad. And she told the police that if they searched his house, if they searched their house, they would find evidence of, I think it was drug dealing. And the police said, oh, can we search the house? And she said, yeah, go ahead and search. And Randolph is like in the car going, you can't search. I don't give consent. And so the question that came before the court was, if 2 people who are both entitled, who both live in a house or an apartment or something, if they're both there and one of them objects to a search, sorry, got distracted for a second there. So anyway, Mr. Randolph said, no, 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 you cannot search. Mrs. Randolph said, yeah, you can go ahead and search. And the court said, if 2 people who have access to that property are both there and one objects, you cannot search without a warrant. You go and get a warrant. But that's an exception to the general rule that if somebody gives consent, the police can search without a warrant. So the last thing about this that I want, warrantless searches that I want to talk about, are what we call administrative and general safety searches. So that involves things like going into a burning building to rescue people, right? Firefighters don't have to get a warrant before they go in, and they do searches afterwards to see how the fire started and that kind of stuff. But other kinds of searches involve things like if there's a railroad accident, they want to drug test the person who was in control of the train to make sure that they didn't contribute to the accident. And in Skinner versus Railway Labor Executives Association, the Supreme Court argued that that was a legitimate policy, and the court did not require the police to get a warrant to do a drug test on a bus driver or a ferry driver or a railroad driver or something like that. On the other hand, the court said this isn't an open-ended thing, right? So in Ferguson versus Charleston, the issue that came before the court was this a policy in a hospital that every woman who gave birth in this hospital would be drug tested, and their baby would be drug tested, and if they found positive evidence of drug use, they would give that information to the police, and then the police could use that evidence against the woman. And the Supreme Court struck that policy down. It had to do a lot with probable cause and reasonable suspicion, that we can't just assume, we can't just go in the interest of helping women get into drug rehabilitation programs or something like that by giving the police information that they could then use for a criminal in a criminal matter. And they said if we allow that kind of intrusive search, pregnant women won't go to the hospital when they need care, and that could jeopardize children even more. So that's not the kind of search that the government could do as a general safety search. The court said that's not allowed. But other things like the police don't, the Transportation Safety Agency, the TSA, they don't have to have a warrant to search a person before they get on a plane. Those are sort of general safety searches. So the last thing that I want to talk about is what happens if the police do conduct a search that turns out to be an illegal search. This is also known as the fruit of the poisonous tree. So if the police conduct an illegal search, what happens to the evidence that is collected? And what happens is, aside from somebody suing the police department for false arrest or something like that, the legal doctrine is known as the exclusionary rule. And what this doctrine is based on is this notion that if police officers conduct an illegal search, whatever they found is poison and can't be used in trial. That's what the exclusionary rule means. It means that if in a trial, when the police move to put evidence in, they want to use evidence. This usually happens before the trial starts, where in the preliminary hearings, the police will present the evidence that they want to use against the defendant. And at that time, the defense attorney can object and say, we object to this evidence coming in because the police didn't have a warrant, or because the search was illegal for some reason. And then the judge has to decide whether or not whether that was or was not an illegal search, whether the person's Fourth Amendment rights were violated. And if the judge determines that the person's Fourth Amendment rights were violated, then they can enact this rule called the exclusionary rule and not allow that evidence to be used in court. So the police, the district attorney, would have to decide whether or not they want to move forward with the case absent that evidence. If they think they still have enough legally seized evidence to make a case that a jury will convict on, then they might go forward with the trial. But if it's like the key piece of evidence, then it may be that they drop the charges against that person. So it's called the exclusionary rule. It was established in 1914, so over 100 years ago, for federal agents. So say for FBI agents conducting searches in federal cases. In a case called Weeks versus the United States, the court said when federal law enforcement agents illegally seize evidence, that evidence cannot be used in federal trial. Well, most trials actually aren't conducted in federal court. And so there was, unless a state enacted its own exclusionary rule in its own state laws, the exclusionary rule didn't apply in state court matters. And most criminal prosecutions take place at the state level. In 1961, in a very important case called Mapp versus Ohio, the Supreme Court extended the exclusionary rule to cover state and local legal proceedings as well. Doralee Mapp was tricked into letting the police come into her house to do a search when the police said they had a warrant, but they really didn't. They essentially had a blank piece of paper, and she was scared, and she let them in, and they found evidence of crime. And in 1961, the Supreme Court ruled that she had been that was an illegal search, and the exclusionary rule should have been used to exclude that evidence from trial. So the exclusionary rule is designed to deter the police from breaking the law. It's designed to deter the police from violating people's Fourth Amendment rights, from either doing a search that violates somebody's rights or doing something like planting evidence and then finding the evidence and using it at trial. It's also intended to protect the integrity of the courts, to make sure that people believe that trials are fair and that people get due process and that judges follow the rule of law. People who are accused of crimes are pretty vulnerable, right? I mean, if they're criminals, we want them to be punished, but we want them to be punished after they get a fair trial. And so the exclusionary rule is actually pretty important. But what happened after 1961 is that defense attorneys would argue that the exclusionary rule applied if any tiny little mistake was made by the police in conducting a search or doing their job. If they made one tiny little mistake, the court would be asked to throw that evidence out. So for example, let's say the police get a warrant. They go through all the proper channels, they've got probable cause, they get the warrant, and lo and behold, there's a typo in the warrant. Somebody signed it in the wrong place, or it's got the wrong date on it, or somebody transposed the numbers on the street address. So they searched the right house, but the warrant actually was for a different house. Those are either clerical errors or human errors. They don't have anything to do with police officers intentionally violating or ignoring potentially somebody's constitutional rights. And that issue came before the court in 1984 in a case called U.S. versus Leon, where the government argued that the exclusionary rule should only be used to deter or punish willful police misconduct, and not to tie the hands of the police so that they literally had to be perfect. And in 1961, the United States Supreme Court was pretty liberal, and so they made a lot of rulings that favored defendants. By 1984, the court was considerably more conservative, and they started making a lot more rulings that gave the police the benefit of the doubt or expanded the ability of the police to do their job. And that was the case in U.S. versus Leon. The court created in U.S. versus Leon an exception to the exclusionary rule. It's called the good faith exception. And so what it means is that even if a judge determines that an illegal search was conducted and that the evidence seized was technically seized, they can still let it in if the error that the police made was either a harmless error, it wasn't something that would normally be associated with violating somebody's rights, like signing the paper on the, one person's supposed to sign here and they sign there. It's a kind of a harmless error. Or if the judge determines that the police officers were acting in good faith, they were trying their best to do what was right, and somehow they made a mistake. The court has said that under those circumstances, a judge is not obligated to exclude that evidence. They can let it in under the good faith exception. So that's a lot about the Fourth Amendment, and I don't expect you to know every single thing there is to know about the Fourth Amendment, but it's so interesting. All of this, to me, is just so interesting because everybody is potentially going to come in contact at some point with the police, whether somebody's done something wrong or whether somebody's maybe a witness to a crime or the police think that somebody might have committed a crime. The Fourth Amendment is a really important guard against the government invading your privacy without some sort of good reason to do so, good and valid reason to do so. So thank you for watching this. Appreciate it.